Ciao. Greetings to His Excellency Francisco Calí, United Nations Special Rapporteur for Indigenous Peoples, and greetings to everyone gathered in Tucson, Arizona, to deliberate on the conditions and rights of Indigenous peoples globally under the theme Racism, Conservation, and Indigenous Peoples Human Rights. I also congratulate Mr. Calí, my former colleague on the CERD, on his recent report. I regret that I cannot be there in person with you because of another engagement on behalf of the CERD, which I chair. However, I could not let this occasion go by without sending a statement of solidarity to you and to the indigenous peoples of the world who are often discriminated against and left behind in the interest of what some call quote unquote development. As a result of the recent controversies surrounding the Maroons of the CARICOM region, I will place my focus there today, as well as remind us all of the importance of the United Nations Declaration on the Rights of Indigenous Peoples. But first, Marinage defined the existence and experiences of our African ancestors wherever they were enslaved or attempts made to enslave them. In fact, in many Caribbean countries, it was the indigenous peoples who were the first Maroons, joined later by enslaved Africans. Maroon communities existed in Africa from among those who fled raiders for captives or escaped from coffles along what were called interior, quote-unquote, slave routes. Communities formed by Maroons dotted the fringes of plantation America, from Brazil to Florida, from Peru to Texas. Maroons could be found in certain areas of North America, including the Great Dismal Swamp, straddling North Carolina and Virginia, the Bas de Fleuve region of Louisiana, and areas occupied by the Seminole Maroons or Seminole Free People, who joined forces with the Seminole First Nation peoples in Florida from approximately 1700 through the 1850s. Maroon communities existed and still exist all across the Caribbean. And here we note the various communities in Jamaica, for example, Nannytown or Moortown, Accompong, and Charlestown, the Samaka or Saramaka and Njuka Maroons of Suriname, and of course, turning to Latin America, especially in Palmares, Brazil, where they are known as Mocambos or Quilumbos, and Mexico, where, as in other Spanish colonized areas like Palenque de San Basilio in Colombia, and the communities in Esmeraldas, Ecuador, and the Mexican Maroons of San Lorenzo de los Negros, they were called Palenques. And these Maroon communities developed from the minute Europeans invaded and attacked indigenous peoples. Not to be forgotten is the legacy of uncompromising abhorrence for repressive regimes and an ideological position which we call the spirit of marinage that accompanied that stance that so many of us embrace or display today. Indeed, the English word maroon, like the French marron, derives from Spanish cimarron, itself based on an Arawakan or Taino root. We have learned that the Taino word semara for arrow signified the ongoing action or flight of an arrow let loose. Gabriel Roca analogizes the Taino meaning of semara to, and I quote, the intentionality of enslaved or colonized people extricating themselves from conditions of oppression. The Black Ladinos and African Bozales, who labored alongside the Taino in Spanish mines and on sugar plantations, and collaborated with them in marinage and protest, likely would have adopted this understanding of the term cimarron, engendering a tradition of resistance. So let us all let go of the colonizer's definition, which suggests that Maroons are wild beasts, or the word maroon or cimarron equals wild beasts. That is their understanding, not our reality and knowledge. So wherever these communities emerged and their people attempted to live as free people, beyond the sight and control of the planters or colonial officials. Wherever they threatened the existence of the institution of slavery, major efforts were made by European militaries to track them down and to destroy their communities, but they never rested until freedom was secured. That is why, in speaking about the rights of indigenous peoples, we must laud the United Nations Declaration on the Rights of Indigenous Peoples, which is key to ensuring such rights. The United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP as we sometimes call it, is an international instrument adopted by the United Nations on September 13, 2007, to enshrine, according to Article 43, the rights that constitute the minimum standards for the survival, dignity, and well-being of the indigenous peoples of the world. The UNDRIP protects collective rights that may not be addressed in other human rights charters that emphasize individual rights, rights that may not be addressed, of course, by human rights charters, and that emphasize individual rights, and it also safeguards the individual rights of indigenous peoples. The Declaration is the product of almost 25 years of deliberation by UN member states and indigenous groups. Among other rights, the Declaration states that indigenous peoples and individuals are free and equal to all other peoples and individuals and have the right to be free from any kind of discrimination in the exercise of their rights, in particular, that based on their indigenous origin or identity. Indigenous peoples have the right to be different, to consider themselves different, and to be respected as such. The General Assembly in 2007 declared that indigenous peoples have the right of self-determination. This is very important. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. In exercising their right to self-determination, they have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means for financing their autonomous functions. Article 5 of the Declaration states that indigenous peoples have the right to maintain and strengthen their distinct political, legal, economic, social, and cultural institutions, while retaining their rights to participate fully, if they so choose, in the political, economic, social, and cultural life of the state. Article 10 makes it clear that indigenous people shall not be forcibly removed from their lands or territories, that no relocation shall take place without the free, prior, and informed consent of the indigenous peoples concerned, and after agreement on just and fair compensation, and where possible, with the option of return. Of course, within some states, controversy surrounds such rights, and Maroons have not always established the boundaries of their lands, which is a priority. Unfortunately, governments in several parts of the world ignore the UN Declaration on the Rights of Indigenous Peoples. Research shows that since the turn of the 21st century, Maroons have taken center stage in the struggle for territory and sovereignty within nation states, for example, in Brazil, Jamaica, and Suriname. Some states have sought to settle such conflicts, but insufficient progress has been made in others. As we enter 2024, it is hoped that these conflicts will be settled amicably. It would help if states parties who are signatories honored the status of Maroons as indigenous peoples and granted them the rights enshrined in the United Nations Declaration on the Rights of Indigenous Peoples. Now, I want to turn to the Committee on the Elimination of Racial Discrimination and the Rights of Indigenous Peoples. How has the CERD tried to hold states parties responsible for ensuring those rights? The rights of indigenous peoples and minorities are enshrined in the International Convention on the Elimination of All Forms of Racial Discrimination, the ICERD. And so each time a state party comes before the committee that implements that convention, the Committee on the Elimination of All Forms of Racial Discrimination And in cases where complaints of violations have been heard, the committee calls on states through the concluding observations to stop these violations. So we can all go to the CERD webpage to see the recommendations we make in the concluding observations. But let me share with you a few of those recommendations. For example, those made in Argentina in 2017, or let me explain. The example made to the state party of Argentina in 2017 when Argentina came before us. Now, CERD asked Argentina to 1. Take special measures or affirmative action to eliminate structural discrimination against Indigenous peoples. 2. Reduce the high levels of poverty prevalent among Indigenous peoples. 3. Strengthen its efforts to address the situation of child malnutrition that is especially prevalent among Indigenous populations there. 4. Draft legislation on combating racial discrimination and promoting the rights of Indigenous peoples in consultation, of course, with those groups so as to put in place a proper legal framework throughout the country. Recalling its General Recommendation number 23 of 1997 on the rights of Indigenous peoples, the committee called upon the state party to establish appropriate regulations and mechanisms throughout the country to ensure that prior consultations conducted with a view to securing free, prior, and informed consent are carried out systematically and in good faith with the relevant representative authorities and through appropriate procedure, with adequate information being provided to the persons concerned. With respect to land rights and land restitution, the committee urged the state party, in coordination with the federal, provincial, and municipal authorities, to ensure and protect Indigenous peoples' right to own, use, develop, and exercise full control of their lands, territories, and resources. Now let me turn to Suriname. With respect to Suriname, when that country came before the CERD in August 2022, many relevant recommendations were made about preserving and protecting the rights of Indigenous peoples. I will just read a few. Recalling its General Recommendation number 23 of 1997 on the rights of Indigenous peoples, the committee recommends that the state party expedite the adoption within a clear time frame of the draft law on the collective rights of Indigenous and tribal peoples, with effective and meaningful participation of Indigenous and tribal peoples and of the concerned civil society organizations. The committee also recommended that the state party adopt measures, including legislative measures, to ensure that Indigenous peoples are provided with effective remedies for all infringements of their individual and collective rights, in particular in relation to the enjoyment of their rights to land, resources, and property, by facilitating their access to domestic courts through their institutional structures, and to recognize the collective legal personality of Indigenous and tribal peoples. The committee also asked the state party of Suriname to take measures to develop and recognize the collective rights of Indigenous and tribal peoples to own, develop, control, and use their lands, resources, and communal territories according to customary laws and the traditional land tenure systems, and to participate in the exploitation, management, and conservation of the associated natural resources through their institutions in accordance with their own traditions. So to conclude, where there continues to be conflict around the rights of Indigenous peoples, let us seek after truth and reconciliation in the spirit and memory of someone who may not have self-identified as Maroon, but who practiced marriage in the way I defined it earlier: ideological resistance to oppressive regimes. That person is the late Archbishop Desmond Tutu of South Africa, who chaired South Africa's Truth and Reconciliation Commission, which was a prudent step for reconciling the South African community. I mention Desmond Tutu because March 21 is South Africa's Human Rights Day. which gave inspiration to the United Nations International Day for the Elimination of Racial Discrimination, also marked on March 21. And of course, that is in memory and honor of the victims of the Sharpeville massacre, part of the anti-apartheid struggle. So let us sing praise songs to the resilient indigenous peoples of the world who for over 500 years in some cases continue to suffer from racial discrimination and the violation of their rights. I wish you all the best with your conference.